You're listening to Audiology. Support our work on Patreon and be sure to submit your requests for topics in the comments below. In the case Citizens United versus Federal Election Commission, decided in 2010, the United States Supreme Court made a pivotal ruling about how money can be spent in political campaigns. The decision, which was split 5-4, stated that under the First Amendment, which protects free speech, the government cannot stop corporations, nonprofit groups, labor unions, and other associations from spending money independently to support or oppose political candidates. This ruling changed previous laws, specifically parts of the Bipartisan Campaign Reform Act, which had banned these kinds of independent spending by corporations and unions. As a result, these organizations can now spend freely on campaign ads and other political activities aiming to influence election outcomes. However, not everyone agreed with this decision. Justice John Paul Stevens, in his disagreement with the majority, said that the ruling goes against what most Americans believe is necessary to keep big corporate interests from having too much influence over our government. On the flip side, the decision has stirred a lot of debate. Supporters, like Senator Mitch McConnell, praised the decision, seeing it as a victory for free speech rights. Meanwhile, critics, including former President Barack Obama, warned that it would give even more power to special interests and lobbyists in Washington, making it easier for them to sway politics and policy. So, this Supreme Court decision remains a hot topic, with strong opinions on both sides about its impact on democracy and free speech. Previously, Citizens United had turned to the McCain-Feingold Act, also known as the 2002 Bipartisan Campaign Reform Act, or BCRA, which prohibits electioneering communications by corporations. In the 2004 presidential race, they lodged a complaint with the Federal Election Commission, arguing that advertisements for Michael Moore's film Fahrenheit 9/11, which was critical of the Bush administration's handling of the September 11th attack, should be considered political advertisements. As such, they believed these advertisements should not be shown within 30 days before primaries or 60 days before general elections. However, the Federal Election Commission did not find any evidence of advertisements featuring a candidate being aired during these restricted periods and dismissed the complaint. As a countermove, Citizens United created its own documentary called Celsius 41.11, aiming its critique at both Fahrenheit 9/11 and John Kerry, the 2004 Democratic presidential candidate. But the Federal Election Commission said that airing Celsius 41.11 and its advertisements would violate the Federal Election Campaign Act since Citizens United was not recognized as a real commercial filmmaker. Following these events, Citizens United aimed to be seen as a legitimate commercial filmmaker before the 2008 elections and produced several documentaries. One of these was Hillary the Movie, a documentary critical of Hillary Clinton. During the 2008 primaries, they attempted to show 3 TV advertisements for the movie and broadcast it on DirecTV. The Federal Election Commission ruled that these actions would breach the BCRA, specifically Section 203, which views any broadcast mentioning a candidate within 60 days of a general election or 30 days of a primary as an electioneering communication. Such activity was forbidden for corporations and labor unions. As a result, the Federal Election Commission blocked the film's broadcast, prompting Citizens United to challenge this decision in court. Back in December 2007, Citizens United took a bold step by challenging certain laws about election-related advertisements, claiming these rules were unconstitutional. Specifically, they were upset about restrictions on corporations and unions spending money on these advertisements, and they didn't think it was fair that their film and a short advertisement about Hillary Clinton were subject to these rules. They also didn't agree with the need to disclose who funded the advertisement or to add disclaimers, citing a previous Supreme Court decision to back up their argument. They ended up in front of a special 3-judge panel because of the serious nature of their claims. However, on January 15, 2008, this panel wasn't convinced by Citizens United's arguments, especially about the film being something other than a direct attempt to influence votes against Hillary Clinton. The panel referenced a past Supreme Court decision that supported the need for disclosure requirements, and they saw the film as a clear case of campaign-related advocacy, which those laws were designed to regulate. The battle didn't end there, though. On July 18, 2008, the court did give Citizens United a bit of a break, saying they couldn't show their film on television close to the Democratic primaries, but they could run advertisement for it. Unhappy with this decision, Citizens United took their fight all the way to the U.S. Supreme Court, hoping for a different outcome. On March 24, 2009, the Supreme Court delved into a significant case. Deputy Solicitor General Malcolm L. Stewart, representing the Federal Election Commission, made a bold statement during the initial argument. He suggested that according to a past ruling in the 1990s Austin versus Michigan Chamber of Commerce, the government had the authority to ban books advocating for or against a candidate if those books were produced or distributed by a corporation or labor union. Stewart even extended this to say the government could prohibit the digital sharing of political books via devices like the Amazon Kindle or block a union from employing someone to write a political book. However, the main issue the court intended to decide, based on a 2012 lookback by Jeffrey Toobin in The New Yorker, was whether Citizens United had the right to air their film. After the justices discussed it, the initial vote sided with Citizens United by a 5-4 margin, mirroring the decision in a similar case from 2007. Chief Justice John Roberts initially penned the opinion that favored allowing the film's showing under Bipartisan Campaign Reform Act guidelines. Yet Justice Anthony Kennedy convinced the majority with his draft opinion that they should take a broader approach. Eventually, Roberts agreed, and Kennedy's views formed the new majority opinion. On the other side, Justice John Paul Stevens tasked Justice David Souter with writing the dissent, which Souter did shortly before retiring. Souter's final dissent didn't just challenge the majority's viewpoint, it revealed deeper tensions within the court, accusing Roberts of manipulating court procedures to achieve a broad ruling that reshaped decades of election law on matters not initially put forth for discussion. Roberts responded to this by withdrawing the initial opinion and expanding the scope of the case for re-argument. This critical re-argument took place on September 9, 2009. It was notable for several reasons. It was one of the first cases Justice Sonia Sotomayor heard after replacing Souter. It marked Elena Kagan's debut as Solicitor General, before she later joined the Supreme Court herself, and it featured prominent legal figures like Ted Olson and Floyd Abrams advocating for Citizens United, with Seth Waxman defending the statute. Legal expert Erwin Chemerinsky highlighted the case's significance for its profound implications on First Amendment rights. On January 21, 2010, the Supreme Court delivered a 5-4 ruling in favor of Citizens United. This decision dramatically changed the landscape of independent political spending by corporations, striking down restrictions set by the Bipartisan Campaign Reform Act as unconstitutional under the First Amendment. Essentially, the court argued that corporations should not face penalties or restrictions for participating in political speech. Justice Anthony Kennedy, writing for the majority, emphasized the heart of the First Amendment. It is there to protect free speech, and this includes not penalizing or restricting citizens or groups of citizens, such as corporations, for engaging in political discussion. Kennedy pointed out an inconsistency in the Bipartisan Campaign Reform Act restrictions, highlighting that they unfairly allowed Congress to limit political speech through various media channels, which should not be the case because, according to him, there is no such thing as too much speech. He critiqued previous decisions that had limited corporate campaign spending, arguing that it is not the government's role to decide if large expenditures by corporations skew public perception or to curb spending based on vague concerns of corruption, which should refer to direct quid pro quo corruption only. The majority also maintained that all associations of individuals, including corporations, have the right to free speech and that spending money is integral for the effective communication of ideas. The court reaffirmed the importance of allowing a free-flowing exchange of ideas without governmental interference. However, the decision was not without its boundaries. It upheld certain provisions of the Bipartisan Campaign Reform Act that required disclosure of campaign funding sources. The majority believed that transparency about who funds political speech is crucial for accountability, allowing both shareholders and the public to see if corporations or politicians are excessively influenced by significant financial contributions. Concurring opinions added depth to the ruling. Chief Justice John Roberts emphasized the importance of occasionally overturning past decisions to correct mistakes and avoid new ones. He pointed out that without such actions, outdated and unjust laws could still be in place today. Justice Antonin Scalia defended the ruling against the dissent's views, particularly those concerning the historical understanding of the First Amendment and the role of corporations. He argued that the First Amendment's protection of free speech does not differentiate based on the speaker's identity, whether an individual or a corporation. Justice Clarence Thomas, while agreeing with the majority, disagreed on the point about disclosure requirements, citing concerns over privacy and the potential for retaliation against contributors. In summary, The Supreme Court's decision in favor of Citizens United marked a significant shift in how political speech funded by corporations is treated, emphasizing the primacy of free speech under the First Amendment, while also recognizing the need for transparency in political contribution. Justice John Paul Stevens, joined by Justices Ruth Bader Ginsburg, Stephen Breyer, and Sonia Sotomayor, voiced a strong dissent to a majority ruling, even taking the unusual step of reading part of his 90-page disagreement in court. Though he agreed with the court's decision to uphold BCRA's rules on transparency, he fundamentally disagreed with the main decision. He expressed deep concern, stating, "The majority ruling threatens to undermine the integrity of elected institutions across the nation. The path it has taken to reach its outcome will, I fear, do damage to this institution." Stevens underscored the importance of public trust in the democratic process by highlighting, "A democracy cannot function effectively when its constituent members believe laws are being bought and sold." Stevens raised a point that the court had overstepped in addressing BCRA Section 203, claiming it was found to be universally unconstitutional despite not being a question initially brought up by those involved in the case. He criticized the majority for altering the case as a pretext to change the law and stressed that historically, the court acknowledged Congress's authority to counteract the undue influence of money in elections as a measure of self-protection for the nation. Reflecting on previous rulings, such as Buckley versus Valeo, Stevens argued that while some direct restrictions on campaign spending had been overturned, the legitimacy of setting limits to prevent corruption was acknowledged, leaving room for future, more precisely crafted regulations. He accused the majority opinion of straying from the logic of earlier campaign finance rulings, emphasizing that undue influence in elections wasn't limited to direct bribery, but could include threats of negative advertising from corporations, leveraging unprecedented power over politicians, an argument supported by the Caperton versus A.T. Massey Coal Company case. Stevens argued that the majority failed to adequately address the risk of a perceived corruptive influence in election, underscoring that public trust in democracy was paramount, and noting that 80% of the public believed corporate independent expenditures could lead to unfair legislative influence. With corporations capable of significantly outspending individual citizens in political arenas, he warned that this could erode public faith in democracy. He further asserted that corporations, as legal entities, should not receive the same First Amendment protections intended for individual self-expression and self-realization. He argued that corporate spending on political advertising, far removed from the essence of political expression protected by the Constitution, should be treated as a business transaction and assessed based on its alignment with shareholder interests, as indicated in the Federal Election Commission versus Beaumont case. After its court win, Citizens United expressed elation, stating, "Today's United States Supreme Court decision is a fantastic win for not just us, but for every American eager to engage in the political scene." This sentiment was echoed across the board by Republican leaders and strategists. Senate Minority Leader Mitch McConnell celebrated the decision, highlighting it as a crucial step toward restoring First Amendment right for numerous groups, allowing them to freely express their political views right up to Election Day. He critiqued the prior restrictions as a form of government overreach that unfairly benefited some while silencing others. Republican campaign strategist Ed Rollins believes this ruling will bring about greater transparency and competitiveness in elections. Cleta Mitchell, a campaign finance lawyer, saw the decision as the elimination of a biased system that favored media corporations over small businesses and nonprofits in political discourse. Hans A. von Spakovsky from the Heritage Foundation praised the restoration of a key aspect of the First Amendment that had been eroded by Congress and earlier court rulings. Contrary to the argument that corporate spending would unduly skew speech rights, John Samples and Ilya Shapiro of the Cato Institute pointed out that this fear was unfounded. Brad Smith, a law professor and former Federal Election Commission chairman, criticized incumbent politicians for trying to suppress political speech, noting that this ruling would empower smaller entities and diverse groups to voice their perspectives. Likewise, campaign finance expert Jan Baran criticized past campaign finance reforms as attempts by sitting politicians to silence their critics, noting that it is simpler to impose legislation on voiceless entities. Finally, the San Antonio Express-News editorial board welcomed the decision for its fairness, pointing out the inconsistency in allowing media companies to endorse candidates while silencing advocacy groups. They acknowledged the problematic influence of money in politics, but argued that limiting political speech wasn't the right solution to this issue. The ruling of Citizens United has sparked a heated debate and continues to be a hot topic among the public. President Barack Obama critiqued the decision, saying it handed more power to special interests and their lobbyists, diminishing the influence of the everyday American who donates modestly to their favored candidates. He went on to say, "This ruling strikes at our democracy itself," and expressed that he couldn't think of anything more harmful to the public's interest. In his 2010 State of the Union address, Obama criticized the Supreme Court's decision, highlighting its potential to allow special interests, including foreign corporations, to have unlimited spending in U.S. elections. This moment was memorable as the camera focused on the Supreme Court justices present, capturing Justice Samuel Alito's silent rebuttal, "Not true." Democratic Senator Russ Feingold, who played a key role in crafting the Bipartisan Campaign Reform Act, called the decision a huge mistake, noting it rolled back decades of limitations on corporate spending in federal elections. Representative Alan Grayson likened it to the worst Supreme Court decision since Dred Scott, suggesting it paves the way for corruption. Senator John McCain, also a co-author of the Bipartisan Campaign Reform Act, predicted backlash due to the increase of corporate and union money in political campaigns, expressing disappointment and lack of surprise given the attitudes of Justices Roberts, Alito, and Scalia. Ralph Nader and other critics viewed the ruling as a gateway for corporations to exert more influence in elections. Former President Jimmy Carter described the U.S. as an oligarchy shaped by unlimited political bribery. Retired Justice Sandra Day O'Connor hinted at worsened issues in campaign contributions for judicial elections. Constitutional law expert Lawrence H. Tribe criticized the decision for allowing the use of others' money in supporting or opposing candidates without individual consent. Harvard's Cass Sunstein marked Citizens United as a dire undermine to democracy, and the New York Times editorial board and others echoed concerns about its implications on political integrity. Regarding public opinion, an ABC Washington Post poll showed that a vast majority, 80%, opposed the ruling shortly after its announcement, with a significant portion desiring the reinstatement of limits on corporate and union spending in elections. Earlier Gallup poll findings showed mixed feelings, with a majority recognizing political donations as a form of free speech, but also supporting limits on campaign contributions. Other polls, including those by conservative organizations, offered varied perspectives, with some showing support for the decision and others indicating a preference for restricting super PAC spending. When the Supreme Court made the Citizens United ruling, many critics thought it would usher in an era where corporations could heavily influence politics to their advantage. However, the reality has been a bit different. A significant portion of the big spending in politics is not coming from corporations, but rather from a select group of billionaires, driven more by their personal ideologies than anything else. The New York Times gathered insights from 7 academics on what they thought the impact of corporate money on politics would be after Citizens United. 3 of them believed the impact would be minor or even positive. For example, Christopher Cotton pointed out that being bombarded with more advertisements does not necessarily change voters' minds and could even backfire on the candidates spending the big bucks. Eugene Volokh noted that media corporations have always had a substantial influence over elections through their coverage and editorial stance. So in his view, allowing more voices to enter the fray, even ones from big corporations like Exxon, could actually diversify the messages voters hear, rather than just let a few media giants dominate conversation. From 2010 to 2020, the top 10 donors and their spouses together contributed $1.2 billion to federal elections, showcasing a significant ramp-up in political spending by a small elite group. This jump in spending reflects a broader trend where nonpartisan independent groups have significantly increased their financial involvement in elections, with spending skyrocketing to $4.5 billion in the decade following the Citizens United decision. The amount of money spent by groups not disclosing their donors also saw a dramatic increase, giving rise to concerns about transparency. Interestingly, out of all the political spending in the 2016 election cycle, super PACs, political action committees that can raise unlimited funds but can't contribute directly to parties or candidates, spend over $1 billion, with the vast majority of this money coming from the top 1% of donors. These super PACs, along with 501c4 groups which focus on advocacy and can spend in political races under certain conditions, have become powerful players post-Citizens United. This has led to a weakening of political parties, a rise in single-issue advocacy groups, and has made it easier for politicians to bypass traditional political channels and norms to promote their agendas. The Citizens United ruling is credited with, or blamed for, depending on your perspective, boosting the electoral prospect of Republican candidates. Research from institutions such as the University of Chicago and Columbia University found the ruling to have considerably benefited GOP candidates at both state and national levels, potentially even altering the balance of power in Congress multiple times had its effects been in play over the past several decades. As the long-term effects of Citizens United continue to unfold, debates over the influence of secret donations, the need for donor transparency, and the transformation of political campaign financing remain central to discussions about democracy and the political process in modern America. Thanks for watching. Share your thoughts in the comments and subscribe for more content.